My name is Kris Stewart, Colorado Springs, Colorado. I'm a licensed school teacher. I've been thoroughly background checked for my teaching license by the Colorado Bureau of Investigations, and I've never been convicted or even charged with any offense greater than a traffic ticket. On April 20th, 2004, I returned home from my job teaching at school to find that my wife had left for an undisclosed location in California and had taken my 12-year-old son with her. I contacted some family friends, and they informed me that she had told them a few months earlier that she was thinking about killing herself and our son, and that on the very day she left, she posted a note to the internet saying that she was contemplating murder and suicide. This falls in line with other threats that she had made over the years, where she threatened to kill herself and my son and was very explicit and gave details about exactly how she would do it and made sure that I knew that there was nothing I could do to stop her. I immediately filed for an emergency order to take temporary custody of my son in order to remove him from danger. I brought the court a collection of writings by my wife that expressed suicidal and homicidal ideation, and statements by witnesses, including one by a registered nurse and one by a social worker, that had personally heard her state that she wanted to kill herself and my son. The order was granted ex parte, that is, without notifying her that I was to pick up the child in California to get him out of danger. However, a clerk of the court, John Stephen Hayes, who I knew about 20 years previously and did not like me, found it fit to contact her by email and tell her about the ex parte order and offer her any help that he could give her. I did complain to the administrator of the court about this because I did receive copies of the emails from the aforementioned family friends. And the reason I got these is because my wife was writing everything and emailing it to these people, and they were quietly forwarding it to me without telling her. So the administrator of the court did say that the court clerk would be disciplined, but I never heard anything more about it. My wife called to appear by telephone, set a hearing to testify by telephone, and she told the court that I would shoot her in the courtroom and that I had a sniper rifle and I would shoot her as she approached the building. Nonetheless, the magistrate Robert C. Earler did order her to appear, and she did appear. He also appointed attorney Aaron Glenn as guardian ad litem and ordered that my wife and I both undergo psychological evaluations. The GAL recommended psychologist Mark H. Hoffman, and I hired him to conduct a psychological evaluation. After I showed Dr. Hoffman the threats that my wife had made and the bizarre and irrational things that she was posting to the internet, he told me that my son was in grave and imminent danger, my wife was seriously mentally ill, and that if I would allow him to be appointed as a court investigator, that he could get my son back safely. I didn't find out till later that for him to solicit or even accept such an appointment was a violation of a Chief Justice directive governing the activities of the courts in domestic cases. Even though, as I found out later from the Chief Justice directive, that all money given to an investigator has to be paid through the court, Hoffman demanded that I personally pay him a $7,000 retainer and reiterated that my son was in serious danger and must be saved. Throughout the pendency of my petition for temporary custody, the court routinely violated rules of civil procedure, Chief Justice directives, and Colorado laws. My motions were routinely ignored, and the GAL investigator and my wife had numerous ex parte communications with the court that were kept secret from me. Even though ex parte meetings with appointees or litigants is completely prohibited in these type of cases, when they meet with the judge. They can meet with the litigants and not tell the other litigant about it, but if they communicate with the court, they have to tell everyone involved and keep everything out in the open. This they did not do. I knew that my wife was sending numerous documents to the court, and I even filed a motion that I be privy to these documents so I could see what was being said, and my motion resulted in silence. I got no answer whatsoever, as with most of my motions. So by the time Dr. Hoffman decided that he had to fly to California to retrieve my son, and I gave him airfare, and by this time I had paid him a total of $8,454, and he hadn't done anything yet. Dr. Hoffman called me from California and told me that he had found my wife and son, who had been in hiding, and that if I did not place $1,000 in cash in his personal bank account immediately and have the bank call him and tell him that the money was deposited, he would quit right then and there and stop investigating. He returned to Colorado the next day and was very furtive, would not tell me what had happened in California. As a matter of fact, he refused to even speak to me for over a month, even though I tried to get him to tell me what was going on. So after his trip to California, the GAL and the magistrate and Dr. Hoffman all started treating me like I was some sort of criminal defendant rather than a litigant. He finally called me on January 6th, 2005, and said that we needed to chat for a few minutes. I slipped a voice recorder into my pocket and went to see him. What followed was an absolutely bizarre 2-hour, 50-minute rant where he accused me of sexual and criminal behavior that I had never even imagined. He told me he was a prophet of God and that the Holy Spirit was telling him that I must never speak to my wife again and I must drop my custody battle and must complete the divorce with no further ado, and that he would negotiate the divorce between my wife and I. He also told me about his promiscuity, his sexual sins, his drug and alcohol abuse. He told me that he had gotten terribly addicted to pornography and terribly addicted to sexual addiction. And I recorded this all, including my vigorous denials of his accusations. Well, I was shocked and stunned by this meeting, but even more shocked when Hoffman finally, after I forced him to submit a report that he had been putting off for a long period of time, and in this report to the court, he fabricated allegations of various sexual and criminal misconduct by me, and not only that, but fabricated confessions in which I admitted to such things. He put on his report that he wrote these confessions down verbatim as they were spoken. When the magistrate asked him and said, "Dr. Hoffman, do you record your sessions with Mr. Stewart? What if he denies saying these things?" He said, "Your Honor, I wrote these down verbatim as they were spoken." Well, at that point, I pulled out a CD, which I might hold up for you, and I said, "Your Honor, I did record our conversations, and if it please the court, I would like to read a few short excerpts from our conversation." Well, at that point, I looked over, and Dr. Hoffman was trembling. And I read excerpts that showed that what I actually said was completely the opposite of what Dr. Hoffman said that I said. And the judge really didn't have much comment on that. So in his report, Dr. Hoffman's appointment was to do a psychological evaluation. He never did a psychological evaluation, but in his report, he recommended that I get a psychological evaluation. He also wanted me to undergo sexual evaluation and criminal evaluation and drug and alcohol evaluation, none of which were even issues as far as I knew. So I had the guardian ad litem, Erin Glenn, listen to my recording, all 2 hours and 49 minutes of it, and she told me that she was absolutely shocked and that if I had not recorded this, no one would have ever believed me. And she told me that after that, she told me she didn't even want to be in the same room with the man because he was so creepy. And she told me that if I hadn't, well, I'd already said that. She told me not to tell the magistrate that she had listened to the recording. So when it came time for a hearing on custody, I could not ask her, Ms. Glenn, have you listened to this recording? Because she made me promise not to tell that she had listened to it. Well, I submitted a rebuttal to Hoffman's report. I included my recording, my digital audio recording. I also included excerpts with the exact time on the recording showing where he had completely contradicted what I had said and how he had completely fabricated confessions. The magistrate did not acknowledge my rebuttal when he made his order, except to say that Mr. Stewart was not happy with Dr. Hoffman's report, and that was all he said. I asked for, during that hearing, a decree of divorce, and the magistrate granted it. And a while later, he made his orders and said that I had no parental rights and had no right to see or speak to my son again. I filed a grievance against Hoffman with the Department of Regulatory Agencies, that is DORA, and Magistrate Erler, at the behest of Hoffman, wrote a letter on judicial letterhead asking DORA not to investigate Hoffman, saying that I should not be allowed to file a grievance. And I have a copy of that here on judicial letterhead, where Dr. Hoffman says, allowing dissatisfied parents to file grievances against psychologists would chill their ability to be effective with the court and reduce their objectivity. Well, I believe it is a basic human right to be able to petition for redress of grievances. And the judge, in his official capacity, said I had no right to file a grievance. Fortunately, the Department of Regulatory Agencies decided that Dr. Hoffman did not enjoy such immunity, and they turned it over to the Attorney General's office for investigation. The Attorney General, Mr. Jim Carr, he was a senior assistant Attorney General for the state, also agreed that Dr. Hoffman did not have immunity and that he could be investigated and sanctioned for this behavior. So since the Attorney General told me that Dr. Hoffman did not have judicial immunity for his clearly illegal actions, I proceeded to sue him in county court for the recovery of all the fees that I paid to him. And in Colorado Revised Statutes, that would be section 1243-266, it states that if someone, well, first of all, I need to back up a little bit. I found out that Dr. Hoffman had never been a licensed psychologist, even though he had been working for the court for about 10 years as a psychologist. So Colorado Revised Statute says that if someone practices psychology without a license, they have committed a Class 2 misdemeanor and shall be prosecuted and punished for that misdemeanor. That is not discretionary. Mr. Carr chose to only hit him with some fairly minor administrative sanctions, and Dr. Hoffman did, in a stipulated order, agree that he had done the things that I said that he had done, acted outside the scope of his appointment, various other things. So even though the 10th Circuit and the 9th Circuit courts have both ruled that officers of the court do not have immunity when they fabricate evidence, Judge Barney Ayupa dismissed my case summarily on the grounds of immunity without further comment. Judges and court appointees to be held to the law and to be punished if they do not follow the law.